law is not stagnant.
Of course.
It's not stagnant, and it's also vibrant. It changes. Good evening.
We from the LAWPOST greet you and feel grateful for your valuable time.
Thank you.
So, first question from the LAWPOST is you have been the Additional Advocate General of Chhattisgarh High Court. What was your experience being that, and what difference does it have being a private practitioner?
Okay, being on the government side, I would say it's a golden opportunity for a lawyer. As a government lawyer, you deal with a big variety of cases, and that adds to the experience and exposure, which you don't get a chance once you are on the private side. Private side, you'll have to wait for that number of cases and that variety of cases. So that is a big advantage, and I would say that in a profession, if we want to sharpen our skills, it's a great opportunity to be on the government side. So that was a good experience altogether on the government side. While talking about the private side, every lawyer is practicing on the private side, which we say it's a practice. So there again things have their own advantages. On the private side, we get cases and we are responsible for each and every case. So we have to put a very hard work while on the private side. We have to study more and things. I would say that on the private side, again, will we have to take chances, and it's all about court craft. Once we are appearing in the court, it's all about court craft. So the real use of the court craft is only in that set. First thing, we should not question the wisdom of the collegium, but still, when it's on the topmost level, it's merit. We count the merit. Seniority does not matter to that extent. So the wisdom of the collegium, they might have gone to for a merit, and this has happened earlier also. So in the profession and elevation of in the higher judiciary, I think so. It's always the merit, but I don't question the other persons who say that they are seniors. They were senior and they have not done. No, it's not that they are less meritorious. But again, it's the wisdom of the collegium. Yes, what I have seen is, or what I feel like I have gone through uh, some pleadings which were in the old files, and I have seen a lot of senior advocates arguing cases, and the present scenario which is prevailing in the courts. Uh, the pleadings were quite detailed earlier. There was a lot of stress on proper pleadings and proper drafting. After that, the arguments in the court were quite lengthy, and a lot of merits were discussed, issues were discussed. What I have seen of late is that everyone is in a hurry. The judges, the advocates, they are in a hurry, and the draftings uh, are just a formality kind of thing. The details are missing, the proper pleadings are missing, even the relief clause is not properly sought, but the petitions are filed. with lot of, I can say, shortcomings. But in earlier petitions, which I have read, earlier files I have read, I have seen it was a very detailed pleadings. So that part on the pleading side is missing in the present scenarios. Secondly, while in the arguments, I said everyone is in a hurry. So the cases are decided without proper arguments. Both the side, the government side, the treasury side, and the private side, they both try to get the decisions without a proper argument. So that is a big drawback which is coming forward, and the new lawyers, the fresh lawyers who are joining, they take the clue from their seniors. So once we miss that part of arguments, the lengthy arguments and detailed arguments in the court, the junior lawyers who are fresh lawyers who are coming to the court, they will think that this is the procedure of arguments and this is the practice, just to say the crux of the case instead of giving each and every details, not going into the case laws or going just into some cursory case laws. So that's a great drawback which is developing in the practice, and we should all, the lawyers, the senior lawyers, even the honorable judges, should make an endeavor that there are proper and good arguments in the court, and that would be beneficial for the junior lawyers also hearing the case to learn and also to experience the cases.
Very good answer.
Uh, Now, law is not stagnant.
Of course.
It's not stagnant, and it's also vibrant. It changes, and it has to change with the society, with the polity and the financial uh, background of the society. Everything has to change, and humanity is always evolving. So the law also has to evolve. Now, presently, if we go into the new areas, lot has been talked about the patents and the commercial side. Apart from the commercial side, which is changing every now and then, and there are improvements every now and then, and with globalization, there has been changes in the law. Lot of things, lot of laws have been introduced, and an effort is being made all over the countries, all over the world. There should be uniformity in the law. Just we are seeing in the arbitration and conciliations proceedings that there should be uniformity. Then environmental laws we are adopting, and it's almost uniform, getting uniform all over the world.